Non-compete agreements are generally legal in Texas, but the difference between legal and enforceable is something that not everyone knows. Before your next key employee signs a non-compete, or before you try to enforce one, you should watch this video. My name is Dustin Lee. I'm the founding attorney here at Ascend Legal Solutions. We are a business law firm based out of Texas that handles all types of business legal matters. This video is completely for educational and informational purposes only. It's not legal advice, tax advice, securities advice, financial advice, or any other type of advice. If you need advice, you should contact a lawyer to get advice about your particular situation. Also, watching this video does not create an attorney-client relationship. First, we're going to talk about what a non-compete is and whether it is legal or enforceable. Second, we're going to talk about the three key elements or factors that a Texas court looks at to determine whether the agreement would be enforceable. Third, we're going to talk about the most common drafting problems that we see in non-compete agreements in Texas. Specifically in my practice, what we see as far as the overbreadth of the non-competes that some people are trying to enforce. Next, we'll talk about how Texas courts actually handle these things once they look at them and they evaluate those factors. What do they do with the non-compete? Fifth is a Texas law-specific issue as well. We'll be looking at exceptions or carve-outs from the traditional rules regarding non-competes. Lastly, we'll be talking about non-solicitation, NDA, or confidentiality agreements that may overlap with this non-compete agreement or even have some of the same benefits to be more enforceable or potentially a better or at least alternative option to the non-compete. All right, let's get into it. First, let's talk about the basic legal foundation in Texas for non-competes. Non-compete agreements, just in general, are legal in Texas. There are a few exceptions, but in general, they are legal. However, the statute and case law that control non-competes in Texas is very specific. And if you don't follow that guidance, if you don't follow those factors, then you could potentially end up with a non-compete that's not enforced. So most people know what a non-compete is, or a covenant not to compete. But if you don't know, non-compete is an agreement type that essentially protects your business from someone who is exiting, like a key employee, an officer, a manager, a key salesperson, something like that. Someone who has detailed information about the inner workings of your business, sometimes like your client list or other confidential information. The non-compete is used to protect your business from that person going out and using that confidential information to start up their own business or to obtain your clients or solicit your clients, or essentially use what they have learned from your business to damage your business. These most commonly appear in employment contracts, in contracts with key level employees like managers, officers, or other key employees like that, and then also in the sale of a business. Now, Texas has a specific statute on non-compete agreements, and you have to follow that statute precisely in order for your non-compete agreement to be legal and enforceable. What are some of the requirements? Well, the first requirement is that the non-compete has to be ancillary to an otherwise valid contract. So what you normally think of is a non-compete agreement that is attached to your employment contract, or a non-compete agreement that is attached to your business formation documents when you form a business with your business partners. Things like that are the normal types of situations. Also, say when you go to sell your business, the new purchaser doesn't want the old owner competing, just going out and starting a brand new business on the next day to compete with the old business that they just sold. So that's another opportunity for the purchaser to put in a non-compete agreement into the business purchase and sale contract. So you see, in all three of those situations, the non-compete agreement is sort of part of or ancillary to an overall enforceable contract about a broader scope of business matters. So now we know a little bit about what a non-compete agreement is, and we also know that if the underlying agreement doesn't hold up, or if there's not an underlying agreement, you may have a problem just to start out with. Okay, next, let's talk about the factors that go into a non-compete agreement. The Texas law is very specific about a three-factor test to evaluate whether your non-compete agreement is enforceable. Now, these are very case-specific and very fact-specific. It's going to be something that you really need the advice of a legal professional, a lawyer on your side to determine whether or not each one of these factors is something that's going to be very fact-specific, very specific as to the situation of your exact case. For that reason, it's very dangerous to try to craft these things on your own. You really ought to get the advice of an experienced business lawyer to help you out. The first factor is the time or duration of the non-compete. So are we talking about 6 months? Are we talking about 2 years? Are we talking about 5 years? Are we talking about 30 years? How long do you want this non-compete to last? Now, the shorter amount of time that it is, the more likely it's going to be enforceable. The longer amount of time it is, the less likely it's going to be enforceable. And the particular circumstances also are going to determine whether this is reasonable in light of the situation. So for example, if you've got a regular old employee and you give give them a 5-year non-compete, that may be unreasonable. Whereas if you have a business owner that you're doing a business sale or a split with, it may be more reasonable to require that business owner not to compete for 5 years instead of 2. Just in general, the longer you go, the more likely it is that it's going to be unenforceable. The second factor is geographic scope. How far away are we extending this non-compete? Is it just going to be within 5 miles of the office, 10 miles? Is it going to be within the city? Is it going to be within the whole state, the whole country? And again, the broader you go here, the more likely it is that this is going to be unenforceable. So if you say within 2 miles of the office, that's going to be a lot more likely to be enforced by a court than if you say across the entire nation. And again, very fact specific here. Is it just a regular old employee? Is it your janitor that we're talking about? Or is it going to be a key member of your organization that we're talking about? Those two people have vastly different access to information, and they have vastly different roles at your business. One standard that's going to be looked at is, where did this employee actually work? Did they work just within a couple miles of the office, or did their service take them further away? Did they have a larger service area than just the city or the town? Maybe they did cover the whole state, in which case maybe a statewide restriction would be more enforceable. Of course, really don't like to take away a person's right to work or right to perform their job for the entire state or the entire country or something very broad like that. If you're looking to enforce something very broad like that, just know that it's going to be difficult, and also they're going to have been a sort of key employee with access to lots of confidential information that maybe a regular employee wouldn't have access to. The third factor is the scope of the restriction. It needs to be tailored narrowly to what the employee actually was doing or what the owner was actually doing. So for example, if the employee was just providing one type of service, it may be difficult for you to enforce a non-compete agreement that covers the entire scope of work that your entire organization covers. So for example, if the employee was an expert at making product A, you may not be able to enforce a non-compete agreement as to products B, C, and D if those are all different products. It's very, very important for you to narrowly tailor the non-compete to match the exact role that the employee was serving. Now, again, there are other ways that we could go about them not using confidential information or not soliciting your clients. We'll talk about that a little bit more at the end. All in all, these 3 limitations need to be tailored specifically to protect your business and as to what your business actually needs, and not to be written in an extremely overbroad fashion, because that might make it unenforceable. Okay, next we'll talk about the common mistakes when drafting a non-compete. Again, the first big mistake that you'll probably make if you're drafting a non-compete without a lawyer on your side, that's mistake number 1. Go get yourself a lawyer. From there, the biggest mistakes in non-competes that I see on a regular basis are usually surrounding the 3 factors, but also sometimes about the actual agreement that underlies the non-compete. So the first factor would be, is there an ancillary agreement? You can't just hand an employee who's already been working there for 5 years a non-compete and say, hey, sign this, because that might not be legal or enforceable, because they already have an employment contract, an employment relationship with you, and you handing them that document, aside from everything else, without any other contract that's associated with, may not be enforceable. The next thing that I see pretty regularly in my practice is someone who comes in and they say, I want my employee to have a 10-year non-compete. Well, I hate to break it to you, but you're probably not going to be able to enforce that. The court's going to want your employee to be able to have a job and work and earn a living at some point. Now, the court does acknowledge that your business does seem to have some sort of restriction to protect it, but it's not going to be a 10-year restriction. So when you're walking into your attorney's office and you hand them a 10-year non-compete for the entire United States of America for all work, they're just going to laugh at you. They're going to tell you it's not enforceable. You've got to narrowly tailor this to what your business actually needs. So that's the biggest one. I see people come in all the time wanting to enforce a non-compete of a very long duration when this is probably not realistic. The second thing that I see all the time in my practice is people trying to put a very broad geographical location on the non-compete. So even though this person has only worked at their office in Houston, they want to put a statewide restriction on this person work. And again, depending on what it is, that's probably not going to be enforceable. It might be, but it's going to be very fact specific. And a lot of times you're not going to be able to enforce a statewide restriction on this person's ability to work. The third one that I regularly see with non-competes is someone that comes in wanting to buy a business, and the purchase and sale agreement does not have a non-compete with the former owners and key employees. That's a really key item that's needed to protect the new buyer and the business from the old owner going out and competing. And I actually see a lot of times the new buyer comes in with an agreement for purchase and sale of this business that doesn't have a non-compete in it. So that's a big one to take out a look look for. So as you can tell, a really broad non-compete that is intended to be really overreaching and really thorough, a lot of times can potentially be non-enforceable. And so you really need to think about, what does your business actually need when you're drafting your non-compete? Next, what do Texas courts actually do with a non-compete if it's not completely enforceable? So the Texas court's not just going to flip a coin here and decide who wins. And in fact, it may not be a winner-loser situation at all. The court may have the power to reform this non-compete to make it a little bit less broad and more enforceable. Okay, step one. Is there an otherwise enforceable agreement that this is associated with? If the answer to that is no, the court's probably just going to say, hey, this is void, it's not enforceable, it's not legal, you can't do anything with it. However, if the non-compete meets that threshold test, then the court's going to look at the three factors. And when the court looks at the three factors, the court actually has the ability to reform or sort of change the scope of the non-compete to restrict it in a little bit of a way to make it enforceable. So if, let's say, the agreement would not have been enforceable at 5 years, but the court believes it's enforceable at 2 years, court may just change it to 2 years. Or if the court says, well, the entire state of Texas is overbroad, you can't enforce that, we're just going to change it to the Houston area or the Austin area, wherever this person worked. And the court may reform it in that way. And if the non-compete is valid and it is enforceable, what does a court do at that point? Well, there's a number of different remedies that we can talk about, but essentially the main remedy that you're usually looking at is injunctive relief. Basically, the court giving an order that says, hey, employee, or hey, former owner, you can no longer compete, because that's what this agreement says. Okay, next we're going to talk about one common misconception as far as non-competes go, and then one exception to the rule. The first common misconception is about a federal law ban on non-competes. So around 2024, the FTC tried to put a nationwide ban on non-competes. I've had a lot of people come into my office since then thinking that non-competes have just been banned nationwide. It's actually not true. There's been a number of cases litigating the issue since then, and just as a general rule of thumb, you can consider the nationwide ban of non-competes not to be in effect. Now, that's not to say the FTC and states don't enforce regulations and rules about non-competes. I mean, Texas, we have our own statute about non-competes and what would be enforceable versus what would not be enforceable. So you don't have to worry about the nationwide ban of non-competes, but you do have to worry about complying with your state's law with respect to non-competes. Next, in Texas, there is an exception to the general rule that non-competes are allowed. Senate Bill 1318 went into effect in September of 2025, so fairly recent, and it is a ban on certain types of non-compete agreements. Now, physicians, doctors were protected against non-compete agreements, and that sort of protection has been extended to other types of healthcare practitioners through this Senate Bill 1318 that is now been passed and affected into law. So these new non-compete protections, not only do they protect physicians, but they've been extended to protect nurses, dentists, PAs, sort of other healthcare type roles. Now, if you're wondering about exactly what healthcare roles are protected, obviously you should seek the advice of a Texas attorney that is experienced in this stuff. Also, you can consult the statute. That sort of general gist of the expansion is healthcare type of workers are now protected in certain scenarios for non-competes. What does that mean for employers? That means that if you haven't revisited your non-competes with these healthcare practitioner type of roles, then it's possible that you may have had a valid non-compete with an employee prior to September of 2025 that is no longer valid. And you need to revisit these, take a look at them, and see if the non-competes that you already had in place were affected by this change in the law. So there are some, you can kind of call them exceptions to the exception, some ways that you potentially could have a valid non-compete with one of these healthcare practitioners. Some of the rules and requirements surrounding that are that, number one, it can't be for a duration of more than 1 year. Number two, it can't be for more than 5 miles of geographical distance from their work location. So things like that apply, and you may be able to actually have a valid non-compete as long as it applies and complies with all these rules. That's something that is, again, very fact specific that you need to consider and really compare what you've got as your non-compete to what's allowed within the statute. So what's the short story here? If you're a healthcare organization and you employ some of these healthcare professionals that may be covered by SB 1318, you need to revisit those non-competes that you have with them to see if they're still enforceable. Next, let's quickly talk about non-solicitation agreements, NDAs, non-disclosure agreements, or they're also called confidentiality agreements. So if you can't have a non-compete, or if you need an agreement that is crafted in slightly a different way, a non-solicitation agreement and a confidentiality agreement can go a long way to cover sort of the same things that a non-compete agreement would cover. So these three instruments sort of work in conjunction with one another, and even if you can't have the non-compete, the other two can provide some coverage for you. So the non-solicitation agreement here in Texas is not really restricted unless you're sort of trying to hide a non-compete agreement inside a non-solicitation. The non-solicitation itself is not banned or anything like that. So you can potentially use a non-solicitation agreement to protect your clients, your vendors, your customers from solicitation, and even your existing employees and contractors from solicitation from someone who is exiting. So for example, in a business sales situation, the buyer of the business wants to make sure that the seller of the business does not immediately go out and solicit and hire all the key employees, and wants to make sure that the seller of the business does not immediately go out and solicit and retain all the clients of the business. And to do that, you can have a non-compete, but also a non-solicitation works for that as well, to protect the existing business from the solicitation activities of the former owner, so that the former owner can't come in and step in and try to solicit those former customers or those employees of the previous business. Now, non-solicitation agreements can be evaluated in the same three criteria manner as a non-compete agreement. Now, it's more likely that they are going to survive scrutiny under that because they're non-compete agreement. But if it's so broad and so far-reaching that the non-solicitation agreement sort of turns into a non-compete agreement, then it may violate some of those factors. So it's important also to look at your non-solicitation agreements to make sure that they would fit within those factors, knowing that they're a little bit more likely to survive scrutiny because they're not an outright non-compete. And then we've got confidentiality agreements, or NDA, non-disclosure agreements. That essentially is the type of agreement that can be used in conjunction with the other two to make sure that the exiting employee, contractor, or owner doesn't use the confidential information of business in a way that would cause harm to the business or, to benefit themselves. So essentially, it's basically saying, hey, you can't use our customer list or our intellectual property or our systems and processes and procedures that we use, our data that you have access to. You can't use these types of things to go out and start a new business to take our customers, because that's our data, that's our process, that's our workflow, that's our customer list. And so again, this is another way to protect that information and prevent it from being used without being an outright non-compete agreement. So you can say, you can't use the confidential information to steal our clients. You can't use the confidential information to steal our employees. You can't use the confidential information in a way that would damage our company. And so that's another way to approach the same situation. It's another tool that is in your arsenal to make sure that your business is protected. The best way to protect a business is to use all three of these in conjunction: the confidentiality agreement, the non-solicitation agreement, and the non-compete agreement, making sure that the terms of each one of these are all structured in a way to where they will survive legal scrutiny by a court. So in this video, we have covered a number of things. We explained what non-compete agreements are, what's a non-solicitation agreement, what's a confidentiality agreement. We went over the requirement of having the non-compete agreement be associated with an ancillary, otherwise enforceable agreement. We also talked about the three factors that courts are going to look at to determine whether it's enforceable. We also talked about how a court is going to treat this, maybe if it's not enforceable, or if it is enforceable, what's a court going to do with it. And then we talked about some of the most common drafting errors or concerns that I see in my everyday practice as to what happens when somebody brings in maybe something that's a little bit too broad, or they want to enforce something that maybe wouldn't comply with the statute. And then we also talked about some carve-outs, some exceptions, and then some other tools that we can use to try to approach the same situation in a different way. So we've seen today also that tackling a non-compete agreement on your own, just with a template, without a lawyer, can be a sort of risky situation. It may increase the amount of risk that your business is exposed to. So we always suggest you get a business law professional in your jurisdiction to help you out with something like that, because the guesswork on what will and will not be enforceable, when you're not a lawyer, when you don't do this every day, you just don't have the legal legal experience to be able to figure out, is this something that's going to be reasonable? So you really ought to contact a lawyer about something like that. And then with respect to some of these exceptions and some of these changes in the law, you also ought to revisit your old agreements to make sure that they still are in compliance with the law. I really appreciate you watching the video. I hope you learned a lot. If you'd like to learn a little bit more about me or our law firm, Ascend Legal Solutions, go ahead and check the link below to check out our website. Thanks, y'all.